Herein it is pretty clear that the petitioners are accused of conduct which threatens the national fabric. The petitioners in their own way have access to thousands of Kenyans. They are politicians, or so-called. When they speak or walk, the thousands admire or follow them, perhaps all for the wrong reasons. It would be more appropriate to have them confined as the DPP wraps up the formal process of charging them. The time for confinement is also to be limited to help equalize the petitioners' rights. Balancing the petitioners' individual interests with those of the public at large, I am convinced that herein rests one instance where the individual interest has to temporarily take a back seat and let the public interest, which is to ensure that the DPP is assisted in his endeavors to preserve the national fabric and cohesion, to take the front seat. It is a small price, the sacrifice of liberty, that the petitioners have to pay. But yet again, it is the Constitution which permits that liberty to be taken away, even if temporarily, if there are compelling reasons. My view is that there were compelling reasons to deny bail and authorize the continued detention of the petitioners. It appears plain to me that in the circumstances of this case, and given the nature of the charges the DPP intends to pursue, it was desirable, and still is desirable, in the course of administration of justice and the public interest, to remand the petitioners in custody for the limited time available, to enable all appropriate reports and investigations to be finalized without even an appearance of interference. I would not intervene by granting any bail. I deny the petitioners their request. That their petitioners appear before the trial magistrate on the scheduled date of June 17, 2016, and renew their bail application. The application stands dismissed with no order as to cause. Justice Oguto upheld the decision of the Chief Magistrate to deny the 6 respondents, to detain the 6 respondents for 2 days. The prosecution had asked for 4 days, but the trial court granted 2 days. I find myself persuaded by the decisions of the Justice Njoki Mwangi and the late Justice Oguto. This court holds that the rights that are afforded to Feisal and Mohamed, in particular that they are innocent until proven guilty, remains inviolable. With regard to public interest, honor, and security, as well as the need to preserve the integrity of the administration of justice, this court holds as follows. It is generally accepted to most people that rhinos are a critically endangered species. Wildlife cases such as these attract interest not because of the respondents in the case, but the fact that the alleged rhino home, for the alleged rhino home to be away from the rhino means that a rhino died. It is as simple as that, and this is one of the factors that causes public interest. The supposed weight and value are an indicator that not anyone can make a demand for a rhino horn. This requires someone ultra-rich with a fetish for a wildlife trophy, and more often than not, these characteristics that drive the rhino horn demand are outside the borders of Kenya, hence the reference to international networks. In the reading of the provisions as stated in Article 49(1)(g) of the Constitution, it may be inferred that the framers of the Constitution intended to stem the tide seen in the Independence Constitution. This was a trend that people would be arrested, detained for unspecified periods of time by the state without knowing where or why. Under the Constitution 2010, the state is obliged to move the court and explain its justification for continued pretrial detention. The difference is night and day, and hence the application such as this one before this court, seeking further detention with the reasons given. In the matter before me, the applicant seeks 10 days. In view of all the above, I find it fit to grant 10 days. Since prior to on the forensics examination of the gadgets not opposed by respondents, I grant it. This is the determination of the court. 1. That this honorable court be and is hereby pleased to issue extended its custodial orders authorizing the detention of the respondents herein for a period of 10 days at Langata Police Station, pending the completion of the investigation into the serious economic crimes and that of dealing with wildlife trophies, specifically rhino horns, contrary to Section 92.2 and 92.4 of the Wildlife Conservation and Management Act. B, that the Honorable Court be and hereby makes an order authorizing the investigating officer, Kokombile, to forensically examine the electronic gadgets, the Techno, and the Infinix. C, the OCS Langata Police Station is to ensure that the respondents have reasonable access to any medication required to manage illness, if all when necessary, to see that the respondents are escorted to a government medical facility for treatment. That there be no orders of costs. The matter will be mentioned to confirm compliance and or any other orders on September 9th, 2025. It is so ordered. Thank you.